Ready? Start. Similarly, as regards the first category of articles meant for the exclusive use of the bride, she would retain her pristine ownership therein, irrespective of her entry and presence in the matrimonial home or that of her parents in law. Stop. Taking all the allegations made above by no stretch of imagination can it be said that the allegations do not prima facie amount to an offense of criminal breach of trust against the respondent. Stop. Thus, there can be no room for doubt that all the facts stated in the complaint constitute an offense under section 406 IPC, and the appellant cannot be denied the right to prove her case at the trial by perempting it at the very behest by the order passed by the High Court. Stop. In one breath, the judges say that the bride is entitled to retain her ownership irrespective of her entry and presence in the matrimonial home, and in the other they come to the conclusion that the moment a married woman enters her matrimonial home, all her properties, including her exclusive property, become a joint property by a fiction of being placed in the custody of her husband or his relations. Stop. While we agree with the first part of the categories as extracted above, we find it difficult to accept the other propositions adumbrated at a later stage of the judgment, which have been fully discussed by us. Stop. We fail to understand how the High Court, while finding that joint enjoyment does not divest a Hindu wife of her exclusive ownership, still choose to treat it a joint property of the two spouses by the mere factum of joint user. Stop. The two views expressed by the High Court stand contradicted by its own findings and are wholly understandable. Stop. Thus, a detailed analysis of the judgment of the Punjab and Haryana High Court in a case appears to us to be a mass of confusion and lacks both clarity and cohesion. Stop. We are therefore unable to upload or support the view of the High Court that upon entering the matrimonial home, the ownership of Stridhan property becomes joint with her husband or his relations. Stop. To this extent, therefore, we overrule this decision and hold that with regard to the Stridhan property of a married woman, even if it is placed in the custody of her husband or in-laws, they would be deemed to be trustees and bound to return the same if and when demanded by her. Stop. Unfortunately, with regard to category, while discussing the question of the rights of the bride to her exclusive property upon her entry in her matrimonial home, the High Court has wrongly applied what it had previously held with regard to category. Stop.